Okay, let's start. Ladies and gentlemen, greetings from Geneva and welcome to the session of Simply Services on Services Domestic Regulation, focusing on the regulatory disciplines from an economic integration and economic benefit perspective. I'm pleased to welcome you to the session, which is going to be conducted in a hybrid format. I'm particularly grateful to presenters from the OECD who are able to join us in person. Simply Services is an informal speaker series developed by the Services Division of the WTO Secretariat for the exchange of knowledge and information on trade in services. It provides a platform for services experts to share their latest relevant work, initiatives, and experiences. Most importantly, I believe that such exchanges among experts and with the practitioners will certainly facilitate the global trade rulemaking and better inform stakeholders and the public. Today's seminar is the 6th event of 2021. It will provide an opportunity to share recent research on domestic regulation by US SEGA, the OECD, and the WTO Secretariat. I believe that this research is very timely and relevant as the 12th WTO Ministerial Conference is fast approaching. There is a strong movement by a significant number of WTO members towards conclusion of negotiations on a set of regulatory disciplines by the ministerial. These disciplines aim to enhance the transparency and predictability of regulatory procedures and reduce administrative bottlenecks in the authorization process for services suppliers. As the nature and the content of these disciplines is almost agreed in negotiations, the research that will be presented to you today is very concrete. It focuses on the specific disciplines under discussion in the joint initiative and looks at their prevalence in services integration agreements and economic benefits that may derive from their implementation. And today's seminar will therefore discuss how the SDR disciplines designed by the joint initiative are comparable to those included across economic integration initiatives, and in particular to some of the most recent trade agreements, and what could be the economic impact of implementing these disciplines at the national level. Now, I'm pleased to introduce Mr. Jeremy Schunk, who will be our moderator today. Jeremy is the Deputy Chief of Party of the US Support for Economic Growth in Asia project. This project is a multi-year project supporting the US government's engagement in APEC and promoting best practices in economic growth in the Indo-Pacific. He's also a principal associate in the economic engagement and private sector development practice at NASEN, an international economic and analytics consulting firm. Jeremy will guide us through the session, but before I give the floor to him, I will also add that, as you can see from the program, we have distinguished presenters from US SEGA, OECD, and from my own team. We are also very happy to have Professor Drake Broekman as our commentator. I'm sure that you will find the seminar enlightening, and useful. As Jeremy will introduce the presenters and to moderate, I will pass the floor to him. Jeremy, the floor is yours. Thank you.
Thank you, Charlene, for the kind introduction. And I'd like to begin just by thanking the WTO for convening today's Simply Services seminar and collaborating with us on this event. The services economy has proven to be a major driver of economic growth and productivity, generating over 2/3 of global GDP, attracting over 3/4 of foreign direct investment in advanced economies, and employing a significant share of workers globally. By liberalizing services markets and facilitating services trade, countries can leverage services sectors to realize strengthened economic performance, particularly amidst and following the COVID-19 pandemic. While there's been some liberalization in services markets in recent years, tools such as the OECD Services Trade Restrictives Index indicate that countries established new barriers to services trade across all major sectors in 2020, despite potential economic gains. The negative impact of this recent trend is magnified when coupled with existing unnecessarily burdensome domestic regulatory systems. Open and transparent domestic regulations for services allow countries to correct market failures, establish a level playing field, protect workers and consumers, ensure access to essential services, and promote adequate service delivery consistent with important regulatory priorities relating to issues such as health, safety, and the environment. Service providers need to seek to rely on transparent and enforceable rules to operate in foreign markets. Where the rules are unclear, domestic and foreign service providers face unnecessary obstacles to enter and operate in markets. This has a particularly negative effect on small and medium enterprises who may lack the resources to find their way through the unfamiliar regulatory system of a foreign market. While countries maintain an inherent right to implement domestic regulations for services, misalignment of approaches can lead to regulations that limit transparency, predictability, and ease of administration, amongst other issues. The U.S. Support for Economic Growth in Asia, or USAIGA program, delivers research, analysis, and technical assistance to strengthen the capacity of the Asia-Pacific Economic Cooperation, or APEC, members to advance regional economic cooperation and achieve goals of free and open trade and investment in the region. To achieve these goals, USAIGA has followed the APEC Group on Services lead to promote domestic regulation of services as a priority issue for improving global trade and services. To bolster these efforts, and aligned with the recent statement of the APEC Group on Services encouraging completion of the WTO Services Domestic Regulation Joint Statement Initiative, USAIGA is pleased to leverage practices and findings from APEC's Services Domestic Regulations initiatives to complement and enhance WTO Services Domestic Regulation efforts. The WTO Services Domestic Regulation Joint Statement Initiative is an important opportunity to address misaligned approaches, lower regulatory barriers, and strengthen standards for transparency and fairness in regulatory processes on a global scale. USAIGA echoes the APEC Group on Services in congratulating joint initiative participants on the progress made to date and encouraging efforts to conclude negotiations by the WTO's 12th Ministerial Conference. Today's seminar will highlight relevant, comprehensive research conducted by USAIGA, the WTO Secretariat, and the OECD with a view to finalize plurilateral negotiations on services domestic regulation, examining two research questions. How are the services domestic regulations disciplines designed by the joint initiative comparable to those included across economic integration initiatives, in particular, some of the most recent trade agreements? And two, what could be the economic impact of implementing services domestic regulation disciplines at the national level? We'll begin with two panel sessions, each 45 minutes in length, presenting the recent research. Following these sessions, we'll hear commentary, providing further insights and responses to the research. Links to all of the papers have been included in the Zoom chat function for your reference. Let's start off with brief introductions to our first speakers. Mr. Marcus Giolito is a counselor with the Trade and Services Division at the World Trade Organization in Geneva. He has more than 15 years of experience in trade and services and served as secretary for the Working Party on Domestic Regulation from 2007 to 2010 and 2014 to the present. Between 2010 and 2013, Mr. Giolito worked as a senior trade and services advisor to the Southern African Development Community, working on the intra-SADC services integration process, as well as EPA services negotiations on behalf of SADC member states. Since 2013, he's rejoined the WTO Trade and Services Division, where he's responsible for domestic regulation, legal issues concerning the GATS, LDC services issues including the services waiver, technical assistance and outreach in trade and services, as well as legal services. Before joining the WTO Secretariat in 1996, he obtained an MA in International Law and Economics from Johns Hopkins University, SAIS in Washington, and he also holds a JD equivalent law degree from Frankfurt University in Germany. Presenting with Mr. Giolito will be Elena Bertola, a legal affairs officer at the Trade and Services and Investment Division at the WTO. As part of the Secretariat, Elena assists WTO members in the negotiations on services domestic regulation. Elena holds a Master in International Law from the Graduate Institute of International and Development Studies of Geneva, and she previously obtained her degree in law from the University of Turin in Italy. Marcus and Elena, the floor is yours.
Thank you very much, Jeremy, and thank you very much, Shaolin, for your introductory remarks. I'm very happy that we can introduce to all participants the results of our research on services domestic regulation, which has been published as a staff research paper, staff working paper very recently. To introduce the work, I wanted to say that the catalyst for this work has been were requests that we received from several WTO members, both participants and non-participants in the joint initiative, who approached the Secretariat and sought assistance in analyzing the domestic regulation disciplines that the initiative had been negotiating. Typically, these requests were motivated by two questions. One, are our own regulatory systems sufficiently aligned with the disciplines so that we as countries can participate confidently in this initiative? And secondly, are there any economic benefits from adhering and implementing to the SDR disciplines? Of course, ultimately, each member needs to carry out analysis for themselves, but what we tried to do as a Secretariat was to assist these efforts, at first by using the World Bank WTO Services Trade Policy Database, ITIP, for which we expanded our segment of data on domestic regulation disciplines in both applied regimes and regional trade agreements. We also use data contained in the OECD and World Bank databases to fill any gaps in our own information. One unique point in the research that I would like to stress is that because the disciplines have been very stable for almost 2 years, this has allowed our research to be very concrete and focus on specific elements of these disciplines rather than go about it in a way that would be more general on the basis of broader regulatory indicators. The paper examines 3 questions. First, it reviews to what extent the SDR disciplines have found their way into bilateral and other preferential services trade agreements. Secondly, the paper assesses the degree to which members have already implemented the disciplines in their own regulatory frameworks. And thirdly, we analyze the potential linkages between the application of the SDR disciplines and economic performance. The first question is the one that Elena will address now, and the last question will be addressed by Laura in session 2. Before I give the floor to Elena, I would like to, Elena, next slide, please. For purposes of our research, we decided to categorize the various SDR disciplines under three main headings: transparency, legal certainty and predictability, and regulatory quality and facilitation. The reason for this categorization is that we wanted to be able to detect possible differences in the prevalence of various types of SDR disciplines in trade agreements. And also we wanted to check whether different disciplines can have more of a role to play than others in stimulating better economic performance. These categories are, of course, somewhat overlapping, and the allocation of individual measures to their respective boxes can give rise to disagreement by otherwise reasonable people, but they serve the basic purpose to show possible differences. So you will see that the results that Elena and Laura will present will always take account of these categories. Let me ask now Elena to walk us through the RTA analysis. Thank you.
Thanks, Marcus, and good afternoon, everyone. My presentation will focus on the first of the three objectives that have guided our research, which is, as Marcus has just explained, the study on the analysis on the prevalence of the services domestic regulation disciplines in regional and bilateral trade agreements. This analysis covers 74 RTAs concluded by 151 WTO members, and this includes several of the most recent new generation agreements. While undertaking this analysis, we looked at specifically the services domestic regulation disciplines that has been designed by the joint initiative, with the objective of mapping out their prevalence in RTAs with the most granular level of details possible. So the distinctive character of this analysis is that we are really being able to cover all the substantive SDR disciplines with only just two exceptions. One is the discipline on non-discrimination between men and women, for which a comparator in RTAs could not be found. And second is a discipline on developing technical standards, domestic technical standards, through open and transparent processes, because this discipline takes a particular angle, and more generally, RTAs contain a provision on the use of international standards. Now, before I move to the findings of our analysis, let me focus on a second on why the linkage between the RTA drafting practice on regulatory matters and the SDR disciplines that are under negotiation in the joint initiative is a particularly important linkage. This is because the inclusion of regulatory measures in RTAs is a good indicator of an economy's capacity to apply these measures multilaterally. And this is particularly so because of the very nature of these disciplines, which in contrast to market access commitments are typically applied on a non-preferential basis, which means beyond the parties to trade agreements only. I will now take you through some of our findings, but for a more complete picture, you should be able to access our paper through the link that has been posted in the chat. So to begin with, and given the increasingly broad scope of RTAs, we'd ask ourselves how widespread has been the inclusion in RTAs of regulatory obligations in line with the SDR disciplines. And what we found is that at present, the adoption of SDR obligations is a fairly established practice. So Typically, earlier RTAs only contain a reference to GATT's Article 6 on domestic regulation. But as you can see from the screen, after 2005, an increasing number of WTO members have agreed to the adoption of regulatory provisions which go beyond the scope of the GATT. So in 2011, the Hong Kong, China, and New Zealand agreement entered into force. And this is one of the very first agreements that covers basically the entire set of SDR disciplines. And since then, by 2015, 98 WTO members have agreed to a set of SDR disciplines in their RTAs. This figure has risen to 112 WTO members in 2020. So what our analysis suggests is that there's this increasing prevalence of SDR related obligations in RTAs is a testament to WTO members' willingness to signal their commitment to good regulatory practice. It's a way to further drive domestic regulatory reforms at the national level and attract interested service suppliers. Now, let me move to a second question that has guided us, which is whether the practice of including SDR obligations in RTAs vary between economies at different level of income and across region. So our analysis show that this practice involves all economies, with only low-income economies to a limited extent. What we found is that almost 40% of the members in our sample have adopted on average at least half of the SDR disciplines. So the figure that you can see on the screen shows the percentages of members that have included the specific SDR discipline at least once in their RTAs relative to members belonging to the same income group. For purposes of this presentation, we have decided to show you a selection of the disciplines, as you can see. But just to give you an overview of measures that would fall under the three categories that Marcus presented. So although the practice, as you can see, of including SDR equivalent obligation in RTAs is more significantly reflected among high-income economies, almost 2/3 of the RTAs in our sample, in which at least one party is a middle or lower income economy, do include GATS plus regulatory obligation. Just to give you one example, which is of course described in more detail in our paper, PACER Plus is an agreement that has been signed in 2020 by Australia, New Zealand, and 9 Pacific islands. And this agreement includes a set of GATS plus SDR obligations, including transparency measures on the publication of new laws and regulation, opportunities for stakeholder engagement, as well as procedural guarantees on the treatment of applications from service suppliers. Now, we also asked the question from a different standpoint, which is whether the practice of including SDR disciplines in RTAs is limited to WTO members that are participating in the joint initiative. Now on the screen, this figure shows the percentages of members that have included each of the disciplines, here again a selection, at least one in their trade agreements, respectively for members that are participating and for those that are not. So while a large incidence of the SDR disciplines in agreements signed by non-participants would not be expected, what we found is in fact the opposite. 32 among the non-participants in our sample have signed to at least 5 of the SDR disciplines, and 8 non-participants have committed in their RTAs to more than half of them. I would like now to provide you an example, which also is an interesting time-related dimension. In 2009, the Asian members, Australia and New Zealand, concluded an agreement which is comparatively unambitious when it comes to regulatory obligations beyond the scope of GATS Article 6. But 11 years later, in 2020, the same treaty partners plus China, Japan, and the Republic of Korea have concluded the Regional Comprehensive Economic Partnership, the so-called RCEP. And I won't go in the details of the SDR obligations in RCEP because I understand the next speaker, Felipe, will do that. But I would like to highlight here that RCEP covers almost entirely the set of SDR disciplines developed by the joint initiative. But at present, only 6 out of the 15 signatories are participating in the joint initiatives negotiations. So looking at this evolution, our paper suggested certain divergence in regulatory frameworks may have made it more challenging to negotiate and agree to an extended set of SDR obligations. But over time, and building on work on good regulatory practice, including at the WTO in the joint initiative, Asian economies, like many other economies around the world, have progressively aligned towards the trend of including a comprehensive set of regulatory provisions in their trade agreements. Now, let me move to one last research question, which is how does the legal nature of regulatory obligations in RTAs compare to that of the SDR disciplines? So this figure on the screen shows the percentages of members that have included either a soft or hard obligation or no obligation on this selection of SDR disciplines relative to all 151 WTO members in our sample. What our analysis found is that the use of soft language is a quite widespread practice among RTAs, and soft obligations are also most prevalent in the SDR disciplines developed by the joint initiative. And this is because soft obligations can serve as a minimum common denominator to reach agreement among trading partners. But interestingly, what we found is that in many RTAs, WTO members have moved beyond soft language, and they actually have included mandatory obligations, hard obligations. For example, particularly, as you can see, in the area of legal certainty and predictability of authorization procedures, but also transparency obligations on the publication of new laws and regulations and the establishment of inquiry point mechanisms. So just to sum up and leave you with some takeaways from this very broad overview that I just gave you. Our analysis just suggests that overall there are drafting variations among the RTAs. There are variations in their level of ambition and in their scope. But the SDR disciplines that the initiative has negotiated and developed are consolidate a treaty drafting practice that has developed over the past 15 years. And from this, we conclude that the establishment of a uniform set of obligations under the WTO legal framework can provide a global baseline for the good practice of services markets, and this can serve as a tool to further stimulate the quality and effectiveness of regulatory frameworks and thereby further support international trade in services. So now this concludes my presentation. I'll be happy to take any questions and give the floor back to Jeremy. Thank you very much.
Thank you very much, Marcus and Elena. I think just to keep things manageable, we'll take questions at the end of the two presentations on this panel. So without further ado then, to get more of a regional perspective, I'll turn the floor over to my US SEGA colleague, Felipe Sandoval. Felipe Sandoval has over 15 years of experience in international economic affairs and international trade. He's led multi-function and multi-organization teams in analysis and negotiation of trade agreements spanning trade and services, international investment law, trade and environment, and digital trade, as well as proven experience on trade policy design and implementation, particularly in the field of sustainable development. In his most recent roles, Mr. Sandoval has been an advisor to the International Center for Trade and Sustainable Development, managing programs on digital trade and cross-border trade and services. Prior to his consulting work, Mr. Sandoval worked with the Chilean government as a legal advisor and counselor for various trade agreements between Chile and other economies. Mr. Sandoval is a licensed attorney and has a master's in law in public and private international law and transnational litigation. Felipe, the floor is yours.
Thank you, Jeremy. And let me upload the presentation, which is here. There we go. Okay, I'm also going to time myself, starting right now. Well, good morning, good afternoon, everyone. Thank you, Jeremy, for the introduction. And thank you all delegates in the WTO for hosting this event. Before I even begin, I think I should make a point in terms of who the audience to this particular presentation will be. And yes, everyone is there. I hope CR room is full. But really what I'm going to, or who I'm going to focus on is those economies or countries who are not yet engaged in the GSI discussion. And in particular, those belonging to the APEC region, who's done so much on domestic regulation and who now have this great opportunity ahead of them looking towards MC12. So what did I do? What did we do at SEGA? Basically, we looked at the 7 non-binding principles for domestic regulations and services negotiated under APEC. These 7 principles break down in 19 specific paragraphs and subparagraphs, each one of them dealing with one or more specific issues or topics. What we did is that we used these 7 non-binding principles developed by APEC member economies, and we run a comparison against 5 initiatives on trade, 5 agreements, both in the Asia Pacific and outside or beyond the Asia Pacific. In particular, we looked at the USMCA, the CPTPP, and RCEP as 3 major Asia Pacific based initiatives. And then we also picked on the UK-EU bilateral treaty out of Brexit, and of course, the joint statement initiative discussion on domestic regulations at the WTO. We did include this too because we also wanted to make a point for the APEC community in terms of how relevant and influential their work has been. In order to do all this, of course, we run not only a global analysis, but individual analysis, which go APEC non-binding principles against each one of these initiatives. And at the end of the paper, the report, of course, there's a section on reflections or conclusions. So on this first slide, what you see is the following. First, focus on the second bottom half. At the bottom, you've got a box that describes all 7 APEC non-binding principles for domestic regulations, from A to G. And under each one of this, you've got the specific or topic-specific paragraphs, 19 in total, which are contained within the 7 principles. So this is the mapping. This is really what we are running the comparison against. Now, when you look at the first half of the page, you will see this line with 5 initiatives: TCA, USMCA, CPTPP, RCEP, and JSI. And under each one of them, you see numbered boxes. These numbers correspond to the specific paragraphs of the APEC non-binding principles. So when a box is in blue, it means that that paragraph, that specific paragraph, has been fully addressed by the agreement under analysis. If the box is shaded, it means that it's only been addressed in part. And if it is left blank, it's because that particular paragraph or subparagraph has not yet been addressed by the agreement in question, at least in the form that the issue has been described under the specific paragraph of the APEC non-binding principle. Now, since the audience today is WTO, I thought it'd be interesting to simply place in the first place the analysis, the comparison between APEC non-binding principles and the joint statement initiatives as we see it today. First of all, good news, which is something that has already been suggested or strongly suggested by Elena and Marcus. Out of the 19 APEC non-binding principles specific paragraphs, 16 are fully addressed by the joint statement initiative. The differences in terms of the substance of the disciplines under negotiation when we compare the JSI against APEC are rather minimal, in my opinion. And basically, they're referred to 3. The first one is on scope. APEC non-binding principles are broader in scope than the JSI. And as you well know, this is logical because the JSI focuses on a subset of DR-related disciplines, licensing requirements and procedures, qualification requirements and procedures, and standards. So that is important, but it's not the entire universe. It does not cover the entire spectrum of DR disciplines as described under the GATS. The second difference, when you go to, well, you'll see it right there, is the only box in blank, box number 19, referring to the subparagraph dealing with business names, the use of business names in the territory in which the service is being provided. Not all treaties address this issue. It's not the most common one, but there is commercial value to it, so it was relevant to include it under APEC study. And the third difference, again, in terms of the substance of what's being negotiated, refers to the legal standards that are used both under the JSI and under the APEC non-binding principle. The general rule under APIC non-binding principles is to use the expression should encourage or should encourage to the extent practicable. This is the general rule. Whereas in the case of the JSI, what WTO members have thus far decided to do is to use the expression shall encourage or shall encourage to the extent practicable. Now, as a former trade negotiator, normally when you would see should and shall as run any comparison between them, you would clearly say, okay, on one side, should is just suggesting, it's more of a soft or softer obligation as compared to shall, saying shall not or shall do, which is a purely binding classic hard rule. But in this particular case, that's not what is going on, because both should and shall are being cushioned by the word encourage or the expression encourage to the extent practicable. Therefore, what in theory or in its purest form could amount to a significant difference between one initiative and the other, because of the more complex language that is cushioning this verb, this should or shall, differences are really not that significant and are certainly not unsurmountable. Now, let's move to the comparison between APEC and RCEP, APEC non-binding principles and RCEP. In this case, and I'm sure we can directly connect this to the reference made by Elena. Yes, still significant convergence between RCEP results and APEC non-binding principles. Indeed, RCEP addresses in full 14 out of the 19 paragraphs of the APEC non-binding principles, but there are some that are not addressed. And I would like to briefly focus on the ones that we at SEGA thought were the most significant ones. Those referred to APEC Principle D, transparency on the left column. You can see in paragraphs 13 and 15, referring to publication and information available and the opportunity to comment and information before entering to force of a regulation. We were not able to find specific references to these two issues under RCEP. And well, yes, you can go through the report and read exactly why or why not. I would also like to draw to your attention to the fact that back in 2019, again, along with SEGA, we developed a full report not only on APEC non-binding principles, but more specifically on Principle D, transparency. And in that report, there's great detail on why transparency is such an important principle within the world of APEC non-binding principles, and why these two specific paragraphs 13 and 15 are probably the most relevant within the space of transparency discussion. Now, when we look at the TCA or the EU-UK bilateral and to the USMCA and to the CPTPP, we basically see that all of them address all of the 19 paragraphs of the APEC non-binding principles in full, either in full or in excess sometimes. And on this, I'd like to mention once again that the largest difference, the most significant, the most profound difference between these three initiatives and the APEC non-binding principles and the JSI for that matter, and almost any other initiative that it's already been agreed, is that in terms of transparency, there is a lot more done. We cannot forget that these three initiatives have not only general chapters on transparency and then specific provisions within services chapters on transparency or services related chapters on transparency. They also include fully fleshed chapters on regulatory coherence or good regulatory practices, which basically deal with transparency and predictability throughout the process of rulemaking and even after a rule has already entered into force. This is sort of follow-up procedure that has been included. And this is something quite unique, quite powerful, and it'd be, of course, for the benefit of all if the WTO at some point could move towards that direction. Main findings of the report. Well, all of the 5 agreements under study address all of the 7 APEC non-binding principles, meaning that no principle per se is left out. However, some of the subparagraphs within some of the principles have been left out partially or entirely. But overall, no APEC non-binding principle has been left out, which is good news. Again, some agreements go beyond what's being provided under the APEC non-binding principles, in particular, those 3 that we just talked about, CPTPP, USMCA, and UK-EU. Most challenges, looking ahead, looking into the future, remain within the space of transparency, and in particular, in the space of the APEC non-binding principles, subparagraphs 12 through 15. Also, when we look at the APEC non-binding principles and now compare them only with regards to the Joint Statement Initiative and the EU-UK initiative agreement, we can say that there is great convergence. It's quite significant. Actually, even the headings that I used to denominate the disciplines negotiated are the same, and the content really it's almost identical. Again, when we look at Joint Statement Initiative, JSI, against APEC non-binding principles, we can see that in terms of the content of the disciplines, substance of the disciplines, the differences are minimal. Number 1, scope, JSI is narrower than APEC. Then the use of slightly different legal standards, and the absence under JSI of a reference to business names. And again, JSI and APEC non-binding principles are not so different when it comes to the use of legal standards, remember. Whereas JSI uses the expression shall encourage or shall encourage to the extent practicable, JSI uses should encourage or should encourage to the extent practicable. As final reflections, and as a good positive message to those APEC member economies who are also sitting today at the WTO table, APEC has proven to be very influential, not only within its own natural space, within its borders, geographical borders, but also beyond. What the EU and the UK did and what you guys are doing now at the WTO is it's faithful to that assessment. What APEC is doing, it's really transcending, and it's improving rulemaking and international conversations well beyond its borders. The second main conclusion, we'll smash it again. APEC non-binding principles are broader in scope than JSI, which means that if you are already part of APEC, if you have already agreed to APEC non-binding principles, then you have already agreed to something bigger than what is being negotiated under GISI, and therefore this should make it easier for you to decide to finally join the GISI discussion and look towards November with a happy face. Third, specific elements of GISI should not dissuade larger participation. Yes, it's again, although there are differences, although there are some challenges, they are not really of a magnitude that should stop you, you referring to those who are not participating yet, in particular those members who are also ASEAN members, should really not stop you from taking the next step and going into GISI with confidence and knowing that you will be negotiating something that you know, that you're familiar with, and that brings in reasonable, addressable challenges. And just to end, yeah, when we looked at, and I'll go back to the APEC GISI picture, excuse me, we referred to the three differences in terms of the content of the disciplines per se. Now, it is also true that those are not the only differences between APEC non-binding principles and GISI, because another significant difference is, it's obvious, is that one is under APEC non-binding form, and the other initiatives, it's being performed, is being pushed under the WTO system. And that implies dispute settlement, and that implies that you may have to come up with a revised or updated schedule of commitments. Now, is that a problem? No, it's not a problem. It's simply the reflection. It is an attribute to the form at which the conversation is taking place. And if you're doing anything under the WTO, you should be aware that those possibilities, I mean, that those enhancements are part of the game, or it could be part of the game. But again, we are talking about extreme similarities between what APEC has done and what the WTO is doing. We're talking about minor differences in terms of content, and we're talking about some more significant differences in terms of the place where the or the form where the discussions are taking place. So to end, my advice would be, and no, I do this responsibly. It's if you're an APEC member, if you negotiate an ASEAN and you're still not joining the WTO GISI, and even if you're not an APEC member and you're still not participating under the GISI, you should really look into it. It is a safe jump. It is a significant jump because it will be the entire world moving towards a better place. Without a doubt, what is agreed under the WTO will have an effect in future initiatives on trade. And I believe personally that it would be a mistake letting this opportunity pass, where everything in the scenario seems to suggest that it is pure benefit, very little cost, rather limited effort, and very significant benefits ahead. And I'm sure that now the OECD Secretariat in the next panel will be able to further develop on this. Thank you so much, and hope to see you all soon.
Thank you so much, Felipe, for your presentation. And thank you again to Marcus and Elena for their presentation as well. We have a few minutes to take some questions from the audience or from people on the chat. If you're in the room, follow the usual protocol. If you're in the chat, I mean, feel free to enter your question into the chat. Do we have any questions from the room?
Not so far, but I will check.
Okay, well, every moderator worth his or her salt has some questions in their back pocket. So maybe I'll pose one for the WTO, but Felipe, you may have some thoughts as well. While this research displays a trend toward greater inclusion of SDR provisions in RTAs and domestic regulatory frameworks, low-income economies are committing to and implementing SDR disciplines to a lesser degree. So for interested low-income economies looking to build capacity or identify a starting point, what do you think are the first steps that can be taken or resources that can be used to become better equipped to integrate SDR provisions in RTAs and regulatory frameworks? Marcus and Elena, do you want to take that one first?
Okay, thanks, Jeremy, for that question. I'll give it a shot. Well, that's not really something that's part of our research, so I'll have to improvise a little bit. First of all, maybe to say that the fact that we did not find SDR disciplines to the same extent in RTAs by low-income economies than for other economies is not necessarily indicative of the domestic implementation and application of such disciplines. It just is more likely that many low-income economies are not engaged in significant RTA activity, particularly in services. For example, in Africa, there are very few services agreements that are in force at the moment. But for example, the African Continental Free Trade Area is a case where we can see that it's a very ambitious liberalization agenda, and African economies are recognizing that market access liberalization on the African continent needs to be underpinned by regulatory disciplines, both in sectors as well as horizontally. So work in the African continent is progressing on a recognition of that, but it is, with regard to regulatory work, still at its early stages. To answer in a little bit more detail your question, or give it a try at least, I would say that the starting point, I believe, for economies to assess what they need to do in order to improve their business climate for service suppliers is to take stock of what they're already doing and what they're not doing, and then to see to what extent they can rely or go back on research and indicators, instruments that exist, and see to what extent they can implement them, to what extent these indicators, they assess them as to be beneficial for themselves, and then can implement them. And for many of this work, there is assistance available by individual cooperation partners, but also by organizations. And with that in mind, then as a third step, they can assess to what extent they should integrate this also in their broader regional agreements or in the WTO, I would say. Thank you.
Thanks, Marcus. Felipe, anything to add on that, or?
Briefly. Thank you, Jeremy. Yeah, again, I'm not an economist. I'm a lawyer, former negotiator, and I'm a consultant. So it's no, I'm not going to go into the well, basically, I'm not going to start saying things that may relate to what the OECD is going to say in a few minutes. But what I think is sort of logical is, domestic regulations is primarily a domestic discussion. It is a discussion you have within the borders of your own country. And whether there are international agreements or this or not, that fact doesn't change. You have rules and regulations within your country that affect the conduction of business. And it is in your own interest to make them as clear, transparent, predictable, and reasonable as you can. How you go about it is a matter of domestic policy, not of international policy in the first place. That said, at the same time that you've got your own domestic agenda, the world runs in tandem, and you have an option. I mean, and you have to make a decision. Will I join the rest of the world or the rest of my region in developing standards that are agreeable to everyone? And that will almost always imply that those international standards or rules will tend to be slightly easier or less demanding than those that you have in your domestic system. It's not always the case, but it's almost always the case. So domestic agenda, international agenda. Now, the question for WTO members is, what if my domestic agenda is not yet very well developed and sophisticated? Should that impede me from joining an international initiative? And my answer to that would be no, it's a big mistake. Well, it is a big mistake for a number of reasons, because you're basically not getting on the train while others are moving forward. You're either static or moving backwards. And second, because under the JSI, for example, and under a number of other initiatives, the asymmetries between countries are being addressed. JSI has a section on development. So they're saying, okay, you've got your own domestic agenda, and now we welcome you to this integrated international agenda, but we acknowledge, we recognize that you may be in a different level of development. So we will provide special treatment for you to facilitate you joining, but at the same time reminding you that you're here to join in full, not just what you want to join on. No, this is the same agreement to everybody, but we acknowledge that there are differences between us or among us. I think that's the name of the game today, and how we are able to accommodate everybody in this more complex, more demanding scenario, but there's also more flexible. And by the way, the GATS has many other flexibilities that other WTO agreements and agreements outside of the WTO do not have.
Thanks, Felipe. I don't see any other questions coming through the chat or from the room. So with that, I'd just like to thank our first set of panelists very much. And we really appreciated your presentations. And let's move right on then to the second session, session 2, on potential economic benefits from implementation of services domestic regulation disciplines. Our first presentation will be a joint presentation from the OECD, from Mr. János Ferenc and Mr. Sebastian Benz. Mr. János Ferenc is a trade policy analyst at the Trade and Services Division at OECD. He works on analyzing policy trends affecting services trade globally using the OECD STRI, and manages the annual update of the STRI regulatory database and indices. Additionally, János's work covers digital trade, focusing on lowering trade barriers for digitally enabled services. He developed the OECD Digital STRI tool and contributed to analysis on digital trade and market openness, cross-border data flows, and the trade implications of new digital technologies such as AI. János also engages with various international and regional partners, including APEC and ASEAN, to assist interested economies in benefiting from the STRI tools. János is a jurist with background in international trade law. Presenting with János will be Dr. Sebastian Benz. Dr. Benz is a trade policy analyst in the Trade of Services Division at OECD. His main areas of work include services regulation, services trade, FDI, and global value chains. Since joining the OECD in 2015, he's led research on services provisions and regional trade agreements, services trade costs, services employment, and firm-level impacts of services trade barriers. Dr. Benz has published several articles and policy papers and has contributed to books in the field of international trade. He has a PhD in economics from the University of Munich and has been a visiting PhD student at Princeton. Without further ado, I'll turn over the floor to Jonas Frenz and Sebastian Benz from the OECD.
Thank you very much, Jeremy, for that kind introduction. Good afternoon, good evening, good morning to everyone. First of all, let me thank the WTO and US SIGA colleagues for including the OECD in this important work. And we are very happy to be here in person at this hybrid event. Our presentation, which is jointly together with my colleague Sebastian Benz, will cover and we look at the benefits of improving regulations on services, on domestic services regulations, particularly looking at the context of the GSI. And we have done some work that covers particularly the APEC economies together with US SIGA. And recently we have expanded this analysis also to look at G20 countries. Today we would like to present both of these studies at this group. The presentation that we have prepared will be structured in two parts. In the first part, I will present some of the key importance of services in this discussion, as well as the tools that we used for this exercise. And my colleague Sebastian will present some of the key findings and policy implications. So can I have the next slide, please? So I think everybody knows in this group how important services are for the global economy. But I think when we look at particularly the recent year, we understand that services are really even more important than before, particularly in terms of driving employment, innovation, productivity. And we also understand better how services provide inputs into processes across different industries, how they are playing an important role as integrated and accompanying components of goods. And particularly in the context of the digital transformation, services have become even more important as it's now much easier to trade them across border. They help lower transaction costs and provide access to new markets. Services, as you can see on the figure, are very important across all income levels. They present on average over 40% of the GDP in low-income countries, over 50% in middle-income countries, and over 70% in high-income countries. Next slide, please. In the context of the COVID-19 pandemic, as we all know, services trade has slowed down substantially. And particularly if we look at a comparison between trade in services and trade in goods, we see that trade in services declined more than trade in goods. And recovery has been much slower for trade in services than for trade in goods. And services particularly were affected by measures that prohibited travel services, transport services that contributed mostly to these findings. But this sharp decline also highlights the importance of identifying new ways on how we can promote the recovery of services trade. And this is where services domestic regulation disciplines can play a very important role. The next slide, please. The OECD has developed a tool in order to strengthen the evidence base for services trade policy. And some of you might be familiar with the Services Trade Restrictiveness Index, or the STRI. This is a tool that brings together laws and regulations for 22 different services sectors across 48 countries, and looks at and collects information from over 16,000 different laws and regulations. The STRI ranges between 0 and 1, where 1 represents the most restrictive regulatory environment. The database and the indices are structured in 5 different policy areas, where we look at restrictions on foreign entry, restrictions on movement of people, discriminatory measures, barriers to competition, and barriers to regulatory transparency. The next slide, please. The framework of the STRI covers a large share of the disciplines included in the WTO Joint Statement Initiative, and we broadly group them in two categories: those that apply economy-wide, so measures in the STRI that we capture across all sectors, and those that are specific to some sectors where licensing regulations or qualifications have a particularly important role. Some examples on the economy-wide measures include the obligations to publish laws and regulations, the need to conduct public consultations on draft laws, regulations related to procedures and costs for registering businesses, or having appropriate judicial redress mechanisms. Sector-specific examples of measures in the STRI include those that look at specific licensing procedures and conditions attached to licensing, including, for instance, the reasons for denying licenses or procedures related to the timeline for granting licenses. Next slide. This slide gives you a sense of the magnitude of domestic regulatory disciplines in the STRI compared to standard market access and national treatment measures. And as you can see, domestic regulations form an important share of the STRI measures across all sectors. In some sectors, they are more relevant than in others, but they together provide an important component of how we assess trade openness across these sectors. And with that, I'll hand it over to my colleague Sebastian, who is going to reflect on the key findings.
Yeah, thanks, János. And hello, everybody. Good morning, good afternoon, good evening, depending on the time zone in which you are. And let me also start by echoing János by thanking the OECD for the opportunity, thanking the WTO for the opportunity to be at this seminar here today, and in particular for the possibility to come down physically from Paris to Geneva to participate in this meeting. Now, with this being said, let me start by saying that the disciplines covered in the JSI, they offer significant potential for reduction of services trade barriers. And let's move to the next slide for this. On this slide, you can see that on average, we expect that the services trade barriers for the G20 countries could fall by around 12%, and for the group of APEC countries for around 14%. And here for this analysis, we measure regulatory barriers to services trade with the methodology of the Services Trade Restrictiveness Index. And we assume that all the disciplines of the JSI are fully implemented in those economies that are covered in the analysis. So you notice that the impact on the G20 countries is slightly smaller. This is because a larger share of the JSI disciplines is already implemented in the domestic laws and regulations of the G20 compared to the APEC economies. Now, let me also highlight some specific sectors. So you see a largest impact in sectors where regulatory aspects and licensing procedures are specifically important, such as telecommunications, computer services, but also professional services, for example, engineering and architecture, also financial services and logistics. Now, let's move to the next slide, please. We use a methodology that we have developed and that we have published and described in a recent OECD trade policy paper to translate these changes in services trade barriers into changes in trade costs. And on this slide, you can see that the streamlining of domestic regulation measures can contribute to a reduction of services trade costs by around 6% for the G20 economies and around 7% for APEC economies. This trade cost effects could materialize in the medium term, and we interpret the medium term as between 3 and 5 years after the implementation of these disciplines. And as on the previous slide, with the reduction of services trade barriers, again, we see the largest impact in highly regulated sectors where licensing, registration processes, and also recognition of qualifications are prominent issues. But the order of the sector changes slightly compared to the previous slide where we only looked at the reduction of services trade barriers. On this slide, you can see that, in fact, the largest impact with more than a 20% reduction in services trade barriers can be found in the commercial banking sector, which is then followed by telecommunications and insurance. And the next slide, please. We also use data on services trade flows in 5 broader services sectors. These 5 broader services sectors are transport, insurance, financial services, communication, and business services, to estimate the total potential of trade cost savings in dollar terms. And on this slide, what you can see with the bars are total trade flows in the G20 and in the APEC region. And with the diamonds and circles, you can see the estimated savings of trade costs that could result from the full implementation of the domestic regulation JSI. And what we find is that these total trade cost savings amount to $75 billion for APEC, and almost double that, $140 billion for the G20. So looking a bit more specifically at the chart, you can see that for the G20, largest trade cost savings would occur in business services and financial services, basically for 2 different reasons. Trade cost savings in business services are particularly high because trade flows, exports and imports of services in this sector are very large in the G20, whereas savings in financial services are very high because here the relative trade cost reduction is larger than for business services. These 2 sectors are followed by transport, communication, and we see the lowest savings of trade costs in the insurance sector for the G20. Whereas for the APEC region, what we see is a more evenly distributed pattern of trade cost savings, with communication, transport, and business services at the top. And for APEC, we see relatively small potential for trade cost savings in financial services because of a relatively lower value of services trade in that sector in the APEC region. Next slide, please. Okay, so let me come to the conclusion, and let me conclude with a brief summary of the key takeaways. First of all, my colleague Janusz already has shown and introduced to you the OECD Services Trade Restrictiveness Index. And what we show with this analysis is that the OECD STRI is a relatively flexible tool that can be used to assess the potential for services liberalization and trade cost reductions of specific reform proposals and policy scenarios. And this is what we have done in this analysis. And what we find is that the full implementation of the domestic regulation JSI would lead to significant improvements in a wide range of trade-related policy areas. And this could reduce services trade costs by around 7% on average in the APEC region and 6% for the G20. And what we also calculate is that the total trade cost savings from this implementation of domestic regulation disciplines are in the range of $75 billion for APEC and $140 billion US dollars for the G20. And an additional remark is that we also expect that small and medium-sized enterprise will benefit most from such reform because dealing with time-consuming procedures and documenting compliance and other tasks are much more challenging for small firms than for large multinationals. So I end here. So thank you very much for your attention. And I'm looking forward to comments or questions.
Thank you very much, Janos and Sebastian, for the presentation. I do, oops, wait, sorry. Okay, moving on, I do see that we have a question in the Q&A, but let's hold the questions if we can until the very end. So with that, let's move on to the presentation from Ms. Laura Biker. Laura Biker is an Economics Affairs Officer in the Traded Services and Investments Division of the WTO. Sorry, I've got like a little bit of technical stuff going on here. Her main responsibilities relate to the collection and analysis of measures affecting services trade in the context of the WTO World Bank Services Trade Policy Database. She obtained a Master of Science in Economic Development and Growth from the University of Groningen and the University of Lund. She also holds a Bachelor of Science in International Economics from the University of Tübingen. Ms. Biker, the floor is yours. Thank you.
Good afternoon, everybody, and thanks, Jeremy, for that kind introduction. So we have already seen the first presentation by Elena and Marcus on part of our paper, and I'm going to present another important aspect of our paper that builds upon the analysis that Elena has just presented. So basically where Elena and Marcus have presented the prevalence of SDR disciplines in RTAs, I'm now going to provide you with more information on the potential linkages between the application of SDR disciplines and economic performance. In the previous presentation, we have seen that there's a growing importance of services domestic regulation in RTAs. We have seen that members are increasingly including SDR provisions as designed by the joint initiative in their regional and bilateral agreements, particularly in so-called new generation agreements. And following this widespread adoption of SDR obligations in RTAs that members have concluded, the question arises as to whether there are potential linkages between the application of SDR disciplines and economic performance. And to approach this question, we use the data that also Elena has just introduced, covering SDR disciplines in 74 RTAs and signed by 151 WTO members. And as Elena already also mentioned, but which I want to emphasize again, is that our analysis is able to cover the full set of disciplines with the exception of two, that is the non-discrimination between man and woman and technical standards. And important here for the purposes of our analysis are basically two assumptions that I want to point out. The first one is that we assume that the SDR provisions included in RTAs have been implemented domestically by members in good faith, which is required by Article 26 of the Vienna Convention on the Law of Treaties. And secondly, we assume that although RTA obligations only appear to the parties that signed the agreement, we assume that the domestic legislation is applicable on a most favored nation basis. And we also believe that this is actually a reasonable assumption, since the implementing regulations of RTA obligations, such as, for example, licensing and qualification requirements or the publication of laws and regulation, will in most cases not differ between the trading partners. So from this database that we constructed, we construct scores that capture the level of application of SDR disciplines for each member, which we then correlate with various indicators of economic performance. And I'm now explaining a little bit on the scores, how we constructed those. So our scores are defined as simple averages across the SDR disciplines, and they range from 0, which means that the discipline is absent in an RTA, to 1, which means that the discipline is included in an RTA. By doing this, by using simple averages, we don't give any priority or hierarchical order to the disciplines. Another aspect is that we are that hard and soft obligations, they are equally awarded a score of 1. So we don't make any distinction here, because the joint initiatives in fact foresees various flexibilities in implementing the disciplines. And so our scores are a closer reflection of the legal nature of the disciplines. Another aspect is that our sample, of course, also includes members that have included more than one RTA. And in such cases, we select the most ambitious obligation of each respective discipline to enter the score. So that means we assume that the respective discipline is applied when the member has included the obligation at least once in its trade agreements. And then we have an overall score, which is the simple average across all of the disciplines that we capture. But we also want to construct scores for subset of measures, which correspond to the 3 categories of disciplines. So basically the 3 categories that Marcus already introduced and that were also used by Elena in her charts. So these disciplines, these scores, ones focus on disciplines on transparency, secondly on legal certainty and predictability, and lastly on regulatory quality and facilitation. So all in all, this gives us 4 different scores on the level of application of the disciplines for each member. Now turning to the analysis. So using these scores, we correlate them with various indicators of economic performance to look at the potential benefits that may arise from the application of the disciplines. So for instance, we look at the linkages with the services sector, we look at linkages with services trade and with GVC participation. For each of these indicators, we then use, for each of these economic indicators, we use averages between 2010 and 2017 to 19, depending on the data availability, so that we can smooth annual fluctuations. And also in all of these correlations, which I'm going to show you in the next few slides, we also show averages for low, lower middle, upper middle, and high income economies, so that we have a comparison basis across income groups. And lastly, important to note is that we are doing here correlation analysis. So we are not able to draw any causal conclusions from that. So just to keep in mind. Now moving to the first set of results is our scores and the relative size of services sectors. And I will first explain briefly the graph. So basically this is a scatter plot plotting our SDR scores that you see on the y-axis against our economic indicator, in this case, services value added relative to GDP on the x-axis. And the percentage of services value added relative to GDP is averaged between 2010 and 19. And it is used to measure the size of an economy's services sector. And each of these black dots that you can see in the scatter plot represents a WTO member in our sample. The different colored lines, they then show linear fits through the sample for each of the four scores that we constructed. And most importantly, our red score that is capturing all the disciplines. And the big orange dots then show averages across the 4 income groups. So far about this graph. And now we basically turning to the to the correlation, we can see that there is an upward slope of the fitted line, and we also have a positive correlation coefficient showing that the size of the services sector is positively associated with the application of SDR disciplines. So we can say members that are on average applying more disciplines are also the ones that tend to have greater services sectors. And the correlation also appears stable if we look at the overall score. So again, the red line here, but as well as the various scores for the categories of disciplines. So we can see that all of these three categories, they comprise equal important pillars of the same relationship. And why did we select services sector? Well, we know that services has become a key driver of the global economy. They have progressively transformed national economies on a massive scale, and they are also the fastest growing economic segment in today's interconnected world. They can create jobs and they can produce efficient allocation of resources or promote firms' competitiveness and productivity. Turning now to the second set of results. So in this graph, we can observe the correlation between our SDR scores and services trade by all four modes of supply, which is averaged from 2010 to 2017. And here again, we can observe a positive slope of the fitted line, suggesting that economies with higher SDR scores, so more SDR disciplines in place, are more actively involved in services trade. And this is again also confirmed when we are looking at the three category slopes separately. Services trade is an important indicator to look at because services trade has grown faster than trade in goods, and it continues to expand. Especially for developing economies, services trade can offer opportunities to build know-how and technological capacity or achieve a competitiveness at the global level. In this manner, cutting red tape and regulatory frameworks is particularly crucial to improve opportunities for suppliers of all sizes to participate in services trade. And it can particularly benefit MSMEs and women entrepreneurs who are typically less well equipped to deal with the costly requirements and procedures. And the last set of results that I want to show you is our scores and global value chain participation, which you can see in this graph. And we can see here an upward trend suggesting that economies with more disciplines in place are also associated with higher participation in global value chains. And this is again confirmed when we look at the various categories of scores that all move in the same manner. And we believe that GVC participation is important to look at because involvement in GVCs can offer enhanced development opportunities for integration into the global economy. The benefits resulting from GVC participation can relate to increased productivity, they can relate to diversification of exports, more employment, or what one could think of spillover effects. And here again, sound and predictable regulatory environments are particularly important for fragmentation of production systems across economies, and removing the red tape and delays and bridging regulatory divergence can be important factors for so-called GVC readiness, and thereby enabling the countries to reap the benefits of participation in global value chains. So I've shown you now 3 of the correlations that we have constructed and used for our paper. And among all of them, we can observe a positive correlation between the application of SDR disciplines and economic performance. And more specifically, we can see that the application of the disciplines is associated with larger domestic services sectors, more services trade, and higher participation in global value chains. And although the analysis is not able to draw causal conclusions from these correlations, the correlation results may suggest that locking in good regulatory practices could provide new opportunities for services suppliers to participate in the global economy. And before I conclude, I would also like to emphasize that in our paper, we also looked at whether the disciplines were implemented domestically. And in order to do so, we make use of a different sample that you will find described in more detail in our paper. But just to point out that we find that these have not been only disciplines have not been only implemented in the context of regional trade agreements, but also at the domestic level. And we have also find similar correlations for adopting the disciplines that confirm the results that we have also just shown you in our presentation today. And lastly, because all this research started from requests by delegations that were interested, as Markus has pointed out at the beginning, we would also like to emphasize that any member who wants to see his performance or position in this research and this analysis can approach us, and we are happy to share our results on the specific member and graphs identifying where they can be found. And hereby I conclude and give back the floor to Jeremy. Thanks very much.
Thank you very much, Laura, and thank you again to the panelists from the OECD for sharing the results of their research. We did have one question in the Q&A, but I think it's been answered, through the Q&A. I also see a lot in the chat just about the availability of the papers. The papers and links to the papers will be made available through the website and through individual emails sent to various participants. So do not worry about that. You will receive links to the papers, but I think Elena is also posting the links again in the chat. Thanks again to the panelists. I think just in the interest of time, perhaps we should just move things along. We have Dr. Jane Drake-Bachman here to speak with us. Dr. Brockman is an industry professor at the Institute for International Trade at the University of Adelaide in Australia. She's widely published and internationally recognized for her expertise on services trade and competitiveness. She's founder and director of the Australian Services Roundtable, has served on the executive committee of the Hong Kong Coalition of Services Industries, and co-convenes the Asia Pacific Services Coalition. Jane also has a strong policy background, having served with the Commonwealth Secretariat, the OECD Secretariat, and the International Trade Center, where she established ITC's Trade and Services Program. A former diplomat, she was chief economist in Australia's Department of Foreign Affairs and Trade and minister at the Australian delegation to the EU in Brussels. She also has practical consultancy background in services trade and regional integration projects across the Asia Pacific, Africa, the Middle East, and the Caribbean. Jane is co-chair of this year's Think 20 Task Force on Trade, Investment, and Growth, and lead author of T20 Policy Brief, out this week, Digital Trade, Top Trade Negotiation Priorities for Cross-Border Data Flows and Online Trade and Services. Without further ado, I'll turn over the floor to Dr. Drake-Bachman for some final commentary on this event. Take it away, Jane.
Thank you very much, Jeremy. And thank you also both to you and to Charlene Chai. It's an absolute privilege to have been present for the launch of so many new research findings. It's impossible really to comment on all of them. And I think all I can really do is perhaps draw out and emphasize some key takeaways that sort of stand out for me, and perhaps fill in a few gaps from a stakeholder perspective. both from an academic, policy research and business community perspective. I'd start by echoing Felipe Sandoval with his reminder that good trade policy always starts at home. I think it's very important that we all remember that this services domestic regulation agenda is what most services businesses see, and it's marvelous that the WTO paper actually describes it this way, and the WTO panelists referred to it this way as the streamlining red tape agenda. And it seems to me that what all the panelists have been talking about today is really the relatively simple idea that every economy should get its own domestic regulatory house in order so that local business can thrive, and getting it right together in a concerted way that's doable and implementable for everyone across all the diversity of the WTO membership. And I think the key to understanding all of the empirical research we've been presented with today is, again, the relatively simple notion that if domestic regulatory regimes are inefficient, local business compliance costs will be high relative to trading partners, and local businesses won't be competitive. They won't be as entrepreneurial as Laura has just shown us in that last presentation. As a result, local businesses won't attract as many international investment partners. They won't be able to integrate as readily in regional or global value chains, as Laura has just shown us. Now, it's actually been a very long session, and some of these research findings may appear at first sight very technical. They're really very straightforward. Let me remind everyone what the WTO Secretariat has shown us today. The evidence is that more efficient services domestic regulation goes hand in hand with larger, more entrepreneurial services sectors, with more active participation in global value chains and stronger trade performance across all four modes of services supply. Four very powerful findings. In fact, there is an evidence base in the economic literature, it goes back over a number of decades, that shows that this kind of trade reform, domestic regulatory reform, unlike trade reform at the border, is really a win-win all around. It leads to a rise in the level of domestic production of services and an increase in the size of the sector. And that's because of the way it impacts on domestic market prices. If I think about this link between efficient regulation and overall economic performance, I recall something I read just last week from the APEC Policy Support Unit. It was reminding us of a piece of empirical research back in 2011, which showed pretty conclusively that services regulation has a significant negative impact on the growth rate of value added, on productivity, and on exports of services dependent industries. Now, that study was based in 2011 on OECD member data, but now 10 years later, the WTO has shown us very similar results across a very wide sweep of WTO members. This is a really important contribution to the literature, and I'm happy to be in a position today on behalf of the research and the business community to say thank you. What regulatory efficiency gains mean in practice out there in the marketplace is that local business will grow. Importantly, local SMEs and micro SMEs will experience the deepest compliance cost reductions and the biggest productivity gains. So the biggest boost to growth and internationalization comes for the services SMEs. And this is why services SMEs everywhere And remember, the services sector is the SME sector. They're all in the same boat. Cutting the cost of doing business is a shared win-win for services business everywhere. This is not a win-lose negotiation. This is a win-win for business everywhere. And typically that's what services business stakeholders say. They say that the single biggest business nightmare is to be tied up in red tape. One of the reasons APEC, for example, went down the track of developing principles on domestic regulation for services is precisely because of the very strong business interest. Survey work back in 2016 on the part of the Pacific Economic Cooperation Council showed that more than 60% of all respondents rated transparency and predictability of services regulations as the most serious impediment to trade in services. And that was the case for all stakeholders who answered that survey: government, business, big firms, small firms, non-services firms, all of them. Every category of respondent rated this as the worst impediment. And it's the only impediment that everyone agreed was top #1 priority. I also, refer back to some very important work by the World Bank in 2014, the Regulatory Assessment Toolkit, which I remember let me quote, services, they said, were the rubber of trade meeting the road of a country's domestic economic conditions, because domestic regulation of services has a significant impact, they said, on the vibrancy of trade in services and also on trade in goods, because services such as telecoms, transport, finance, energy are all inputs into the manufacturing process. Now, when I think about the specific regional and bilateral agreements, which Felipe and Marcus also discussed, I want to just indicate, I suppose, that when APEC set out to develop its own principles, which it adopted in 2018, the explicit idea was to respect the region's diverse socioeconomic realities. And so it is also with the principles emerging in the WTO SDR initiative. First, they're closely modelled on the APEC principles, and second, and I was struck by this finding in the OECD, in the WTO paper, that some lower income countries may need technical assistance to implement commitments of this kind. I felt that emerged very clearly from some of the graphs in Marcus's presentation. Now, technical assistance of this kind is abundantly available in the APEC region, but in other regions, perhaps, I think that one message I detected today from the WTO work is an implicit message there for future global aid for trade. I also want to back up Felipe's presentation by noting that in many cases, the provisions out there in regional agreements go further than the emerging outcome in the WTO. He mentioned CPTPP, but I'd like to mention RCEP, which seems to me to go further also in a number of areas, including technical standards and on professional recognition, for example. And in many other areas, sometimes the text is different. And unlike Felipe, I'm not a trade lawyer, I'm an economist, but frankly, I think the text often means exactly the same thing, particularly on authorization fees, for example, or acceptance of copies. So one thing that I feel emerges from the comparison of so much text, which is all gravitating to the same end, is that we have a unique opportunity right now in the interest of the multilateral trading system and in the interest of global recovery of trade and services to multilateralize these many bilateral and regional outcomes that are out there. this would seem the low-hanging fruit that's ready to harvest. Apart from the very important LDC services waiver, which was specific for LDCs, this would be the first and only outcome on services in the nearly 30 years since the WTO was created. And in my view, it's in no economy's interest to hold back because of the OECD's trade cost story we heard today. Sebastian said he was looking forward to comment. Well, let me just say, Sebastian, I would have to say no one is going to forget $140 billion. 140 billion US dollars is what the trade cost saving amounts to for the G20. The business community isn't going to let anybody forget that number, is what I feel. A 6% cut in trade costs across all services sectors for the G20, a 7% cut on average across all services sectors in Asia Pacific, and in the fastest growing, most rapidly digitalizing of the services sectors, business services, the G20 could cut trade costs in that sector alone by 65 billion. That was the number on Sebastian's graph. And in the APEC region, there was no number, but my read of his graph was it would be about 20 billion. Cuts in transport costs look particularly deep too. About 23 billion, I think it was, for APEC, and for the G20, 50 billion odd. These are very big numbers. They're not numbers any government or any business can afford to ignore. And for SMEs, this kind of magnitude means business survival. They're powerful research findings, and thank you to the OECD for doing the work. It's not easy work, and these insights are invaluable. We've long known that trade costs for services were more than for goods, but actually we didn't know until the WTO showed very clearly in the 2019 World Trade Report that they were double. And I don't think we really knew for sure before today's seminar that 40% of these costs are regulation related. That was Marcus's figure. And that market access and national treatment restrictions account for only 60% of the trade costs. And let me be blunt, regulatory mess accounts for the other 40%. And Janos had an extraordinary slide showing that for telecoms, it's 60% of the restrictiveness problem. These are fascinating results and worth real policy and negotiation reflecting. I think I want to quickly address another point that the WTO Secretariat made, which needs to be addressed, and that is this notion that most JSI participants are doing it anyway with or without the JSI. Now, I think it's important to remind everybody, and in fact, I want to again quote something I read this week. It was written by Ben Shepard and Bernard Hoekman and Anirudh Shingal, but they said that even if countries are already doing it, codifying good regulatory practices into law, including simple things like stakeholder consultation, can make all stakeholders more comfortable that they will have an opportunity to have a say. And that can make all the difference for MSMEs seeking to engage with offshore partners in global value chains. Finally, I think, please correct me, Janos and Sebastian, if I misheard and got this wrong, but as I understood it, if we look behind those averages of 6 and 7%, I think Sebastian said the cuts in trade costs were very much higher for the two big economy-wide infrastructural services, telecommunications and financial services. followed by computer services, some of the professions, and logistics. Now, all of those are equally infrastructural for the new digital economy. I'm very aware of the time, Jeremy. I would like to point out some quite important results there on the STRI, but I know I don't really have time to go into detail. But it is really worth noting there that I think it stood out for me that the STRI reductions were bigger for the APEC region than for the G20 as a whole. For the APEC region, for computer services, the average opening up is 21%. And for accounting, motion pictures, rail, freight, logistics, insurance, commercial banking, telecoms, architecture, sound recording, engineering, the average opening up is over 11%. So when we go back and look behind the averages also for the G20, we see some quite extraordinary things. For other commercial services, the drop in trade costs is nearly 30%. Now, when you get to the point where you look at what does this mean for SMEs, and the OECD is telling us at least 2 to 3 percentage points on top for SMEs. So we're talking an average 9 to 10% trade cost reduction for SMEs in APEC and an average 8 or 9% trade cost reduction for SMEs in the G20. And in some sectors, that's going to be over 30%. It's going to go from 29% to up to 33% cost reduction. It's just absolutely dramatic. So the message is just abundantly clear. The single decision to join the WTO JSI on services domestic regulation would deliver measurable results for industry. And now we know exactly what it's worth. It's worth 140 billion for the G20. The inescapable conclusion, I would have thought, is that we all need efficient services regulatory regimes. Every WTO member stands to gain. All firms, including merchandise goods firms, will benefit from removal of inefficient red tape. It's pretty clear that a lot is at stake here for services trade growth and for post-pandemic recovery. Thank you, Jeremy.
Thank you very much, Jean, for that. I know that we are sort of past time, but if anyone has any questions or comments from Jean, we could probably take one. By the way, too, I'm not being shy. Something has gone wrong with the video camera on my screen. So that's why you're not seeing me on video. But if there are no other questions or comments, thank you very much, Jean, for the insightful commentary on the presentations. As we discussed throughout this seminar, WTO members are well equipped to embark on services domestic regulation reform and realize improved GDP, lower trade costs, larger service sectors, greater participation in global value chains, and higher levels of entrepreneurship. The trend towards the inclusion of SDR disciplines and RTAs in domestic regulatory frameworks is reflected among economies at all levels of income and across all regions of the world, with only low-income economies to a limited extent. Resources and reference points are available to these economies to build capacity to integrate SDR provisions in RTAs and regulatory frameworks. The joint initiative is an important opportunity to address misaligned approaches, lower regulatory barriers, and strengthen standards for transparency and fairness in regulatory processes on a global scale. As noted by the WTO research, an outcome on services domestic regulation would not only constitute a global benchmark for locking in good regulatory practices for services markets, but the greater level of coherence at the international level that will result from such an outcome would provide new opportunities for service suppliers to participate in international trade. With these findings, we once again echo encouragement of efforts to conclude joint initiative negotiations by the WTO's 12th Ministerial Conference. To close today's session, I'd like to thank the WTO for convening today's Simply Services seminar. I'd also like to thank our speakers from the OECD, WTO, Institute of International Trade, and US-SIGA for their presentations. Thank you all to all the support staff on the tech side who also helped make this happen. Just like to note in conclusion that all presentations will be posted on the WTO website in the coming days, and participants will be sent this link. Thank you again to everyone who participated in this seminar. It's been a pleasure to be with you during my morning, your afternoon. With that, let's conclude the seminar. Thank you again. Have an excellent day.